Good morning. I'm Brian Goldberg. Talk a little bit about some sales tax cases. Also happy to report that we have one to discuss that we won. Also, I want to recognize the litigators who did a really good job of handling this case, who are in the room here in the back, Seth Schriftman and Tina Tsatsoulis. They did a great job. This case is Midwest Medical Equipment Solutions versus Department of Revenue. It involved the government body exemption and dealt with managed care organization plans, Medicaid enrollees. So what happened was before the state began contracting with these managed care plans, the state would reimburse Midwest Medical directly for their sales to Medicaid enrollees. Then, I guess about 10 years ago, the state began using these managed care plans, and Midwest continued to treat these sales of medical equipment such as breast pumps and nebulizers. Midwest continued to treat them as sales to government bodies, notwithstanding the fact that the payments were coming from the managed care plans and not the state directly. And in this case, the taxpayer Midwest Medical, they made a few arguments to try to justify their treatment of these sales as exempt. They tried the substance over form doctrine, which the tribunal rejected, finding that under the contracts at issue between Midwest Medical and the managed care plans, it was very clear that the managed care organizations and not the state were the true purchasers. They weren't just mere intermediaries, like was the case in the precedents that Midwest was trying to rely on. This wasn't just an intermediary thing. They were really contracting with Midwest and negotiating the rates, and the payments were coming from the managed care plans and not the state directly. The tribunal also rejected the agency theory. The court looked at the contracts, and it was clear from the contracts that these managed care organizations were not acting as agents of the state, and even if they were, the law surrounding the government body exemption makes clear that even if they were agents, the government body exemption is not available to agents of the state, but only to the state itself. Another noteworthy thing about this case, just like the PepsiCo decision, the tribunal here upheld the imposition of penalties. The court noted that the taxpayer's position was undermined by the contracts at issue. The case law was pretty clear that these kind of indirect payments by downstream vendors are not subject to the government body exemption, and just because the taxpayer had this argument that it was trying to collapse the various transactions into a transaction between the state and the retailer, that argument was not enough to avoid the imposition of penalties. The next case I wanted to mention is one that was just recently filed. It's got a long way to go. We don't have a decision, but it's one to keep an eye on. Adoramic Camera is a New York retailer of cameras and photography equipment. They're subject to collecting use tax under the economic nexus law that went into effect after Wayfair. In their petition, they raised some, they cite some facts that they had a lot of issues coming into compliance with these requirements following the enactment of the law. They had software issues, bringing their software up to date to comply with the requirements. It took them until, I think it was February of 2020 to be able to collect the use tax from their Illinois customers. So they're making a number of constitutional arguments under the Commerce Clause and the Due Process Clause. First, they're alleging that it's an unconstitutional burden under the Commerce Clause to require to collect use tax so soon after the Wayfair decision. They're saying that we didn't give them enough time to come into compliance, which they're saying makes it effectively a retroactive requirement. They're also alleging that the statute violates the Commerce Clause as applied because it doesn't have extensive virtual contacts with Illinois. They distinguish themselves from the big retailers like Wayfair, saying they're just a small market retailer with a static website. So they're not purposely availing themselves of the local Illinois market. They're not advertising to Illinois customers. They just have this static website that accepts orders from Illinois customers, which they're arguing does not subject it to tax under the Commerce Clause and Due Process Clause. And with that, I'll turn it over to the regulatory portion of the program.